Hi, everybody. This is Mrs. McManus, and this is a screencast that will discuss the sources of law and how we classify crimes in the state of Massachusetts and in the United States. So, first, let's talk a little bit about criminal justice systems around the world, because I think it's important to note that there's not the same kind of system in every country. And so, the first one is the inquisitory system. We do not have this system in the United States. This is a system where the defendant actually has to prove his or her innocence. So, the judges in these systems are much more active in the actual trial procedure. They play a much bigger role. In addition, it doesn't protect the defendant nearly as much as the system of the adversarial system. And where you can find this typically is in countries in Europe, such as France and Italy, and then in many other countries in South America, in Africa, and in Asia as well. Now, the United States, we have the adversarial system or the adversary system. And this system is based on a few really important premises. The first one, that the accused are innocent, and they are innocent until proven guilty. Now, you've probably heard that many times on police shows that maybe you watched on TV or perhaps movies that you've seen as well. And the accused do not actually have to prove their innocence. That is the government's responsibility. And you might say, well, I don't see the government when I watch Law and Order or other TV shows like that. And actually, yeah, you do. The police officers aren't the ones that actually have to prove the guilt within an actual trial, but there are people at the state level here in Massachusetts called assistant district attorneys and district attorneys. And their job is to represent the government and to prosecute people, meaning to prove that they are guilty of committing a particular crime. Now, at the federal level, the people who are prosecutors are actually called U.S. attorneys. And again, you may have heard of them before. Now, our adversary system is guided by two very important principles: due process and equal protection, which we'll talk more about in just a moment. In due process, or with this concept of due process, this means that if you are accused of a crime, then you are processed through our criminal justice system with basic rights afforded to you by the Constitution. And we're not just talking the United States Constitution, we're talking about the Massachusetts Constitution as well. Now, it's important. It's very important to have due process because we need to think about the power of the government. The government has tremendous power in our criminal justice system. If you take a minute to stop and think, the government has the right to take away your liberty and to take away potentially your life. And let me explain. If you are found guilty of a crime, then they have the ability to recommend to the judge that you are placed in prison or jail. If you are found guilty of a crime at the federal level, you may, in fact, actually have the death penalty recommended, which means that the government has the power to take away your life. So, again, they have tremendous power. Now, theoretically, due process exists to prevent the prosecutor from finding or obtaining a guilty verdict if you're innocent, meaning because we have this innocent until proven guilty concept, and because the prosecutors are supposed to only prosecute you if they in fact think you're guilty of a crime because they have to go through due process, then theoretically, nobody should be found guilty of a crime if they're in fact innocent. I say theoretically, guys, because this is unfortunately not the case. There are many, many, many people who have been found guilty of a crime that they in fact did not commit. And you'll see that there are various websites that exist, for example, at the federal level, particularly in terms of the death penalty. There is if you were to go and look, you can actually see a list of people who were put to death who in fact were not guilty of that crime and were later exonerated, sometimes because of confessions by other people or sometimes because of DNA evidence as well. So I want you to take a moment and stop and think, okay, what kinds of basic rights are we guaranteed if we are accused of a crime? So think back to maybe when you learned a little bit about the Constitution or maybe some of those police shows that you watched and brainstorm a list of what kinds of basic rights are guaranteed. So now that you have a list, some ones that perhaps you had on that list were perhaps the right to a lawyer, the right to be free from cruel and unusual punishments, Maybe you had the right to be free from unreasonable searches and seizures. These are all incredibly important rights that we have if we are accused of a crime. In addition to that, here's one more, which is equal protection. This comes from the 14th Amendment. The 14th Amendment was passed after the Civil War ended in 1860s, and it says that no one shall be deprived of life, liberty, or property without the due process of law. Meaning everyone needs to be treated the same in the criminal justice system. You cannot be discriminated against because of your race, because of your gender, minority status, or religion. And there are so many equal protection claims that have been filed and lawsuits that have been filed. This has come to be a very important amendment in the Constitution. And I'm not saying that the other ones aren't important, but this one has perhaps gotten just a little bit more press lately, particularly in the last few decades. So going on to where we get our laws. So you probably have learned about this in some way, shape, or form before. But of course, first is the Constitution. So we have not only a US Constitution, which is the set of laws for our entire country, but we also have the Constitution of our respective states. So we have one here in the state of Massachusetts, which in fact probably has more rights and freedoms afforded to us than even the federal Constitution does. Then we have these things called statutes, which is a fancy word for laws. But these are laws that the legislature has originated and they have passed. And so when you think of the state of Massachusetts, these laws or statutes are passed by the state House of Representatives and the state Senate. And then thirdly, court decisions. Court decisions are really kind of an interesting thing. They don't necessarily like sit down and write statutes like you might see in the legislature, but because of the decisions they make, they in fact might become laws thereafter. For example, let me think of a good example. For example, very recently in the last decade, same-sex marriage has been approved in the entire United States. Now, previously, that had only been a state-by-state thing, and not all states had that law in the books. But because there were some lawsuits where people were trying to say that it shouldn't be a law and it shouldn't be allowed in particular states, the United States Supreme Court took that case and they handed down a decision that said that same-sex marriage would be legal in the United States. So de facto, they essentially created a law that is now part of the fabric of the United States. So, as I talked about before, you could either have state laws, but you also have federal laws. So at the federal level, our legislature, if you remember from 8th grade history perhaps, the federal level is made up out of the US House of Representatives and the US Senate. And so, of course, for a law to become a law, it has to be passed by both houses of Congress and then, of course, signed by the president. Now, very important thought about statutes is that they cannot supersede the constitutions, meaning the state of Massachusetts cannot pass a law that says the police can search anyone anytime that they want, any place. Absolutely not. They can't pass that kind of law because the United States Constitution says that we're protected from unreasonable searches and seizures. And so where sometimes you see cases go to the Supreme Court is because states are trying to make laws that interfere with the Constitution. And that, of course, is going to get very dicey. Now, a quick word about case law versus common law. Case law is what I already talked to you about, is that they come from court decisions. Common law is actually sort of what the United States system of justice is based off of. And this actually comes from England. Now, remember back in the day, you learned that the United States was colonized by England and Great Britain. And so therefore, perhaps it makes sense that a lot of our laws came from somewhere else first. And so these are customs and traditions and judicial decisions that maybe weren't statutes to begin with, but have just sort of been passed down almost like tradition, from generation to generation. Now, the United States has taken many of these things that were once considered common law and codified them, meaning put them down in the books. But I did want to at least mention that because you might hear that come up. Now, another word about administrative laws. These are rules that agencies may actually make up. So, of course, it's going to be impossible for state legislatures and Congress to rule on everything, right? It's impossible for them to do that. So they say, okay, the Environmental Protection Agency will allow you to make some rules. They'll say, okay, the Housing Authority will allow you to make some rules too. At the state level, they allow prison officials to make rules regarding their own prisons. Now, if you violate an administrative law, there's typically not a criminal punishment inflicted, but there are some exceptions. So let me give you an example. Let's say a restaurant has exceptionally gross food. A state agency steps in and says, we found cockroaches in your food. It's gross. You need to clean up, you need to become sanitary, and so on and so forth. Now, if the restaurant doesn't do this, then that state agency can actually go in and get a court order saying you must clean up your act or else we're going to shut you down. And if they violate that order, the restaurant actually might be cited for a criminal offense, meaning they might have to pay a fine or perhaps even jail time, although that's, not extremely typical. Now, of course, they're not usually treated the same way as violent offenders, but this is one way in which you might have some administrative laws that can actually become criminal and go to court. When we talk about categories of crime, we're talking about, how do we know that a crime's really bad and how do we know that, it's maybe not so bad, which is hard to say because, theoretically, if you're breaking the law, you're typically doing something that you're not supposed to be doing. So there are two categories. The first one is a misdemeanor. A misdemeanor is a less serious offense. It could be punishable by a fine or perhaps probation or perhaps a short jail term. Typically, the jail term is 2.5 years or less. A felony is a serious offense, which is punishable by more than a year in prison or perhaps even capital punishment. So let's look right here if you can figure out if it's a felony or a misdemeanor. So let's start with rape. Would we think of it as a more serious offense that has longer prison punishments? And in fact, yes, it is a felony. Oh, I clicked too soon. Shoplifting. If you're shoplifting something under $250, it would be considered a misdemeanor. So a less serious offense that would perhaps have less consequences than a felony. Breaking and entering during the day, is it a misdemeanor or a felony? It is a felony. And so again, a more serious offense. Manslaughter, which is, falls under that category of homicide. Manslaughter is considered to be felony. Assault. Assault is in fact misdemeanor. Now it can change though, of course, if you have assault and battery or assault and battery with a deadly weapon, then that might change and things might become a felony instead. It's going to depend on each state law. Driving under the influence. In the state of Massachusetts, it is a misdemeanor. However, the state of Massachusetts has incredibly strict driving under the influence laws. Now, one thing I wanted to mention is that I talked about how misdemeanors had jail time and you might be sentenced to 2.5 years in jail versus a felony you might have to go to prison. There actually is a difference. In the state of Massachusetts, a jail is run by a sheriff, and the sheriff is actually voted into office. And so these are typically designed to hold people with short sentences. You might see work release programs. They oftentimes will have programs to help people with substance abuse, or perhaps they might give them vocational training so that they can go out to the community when their sentence is done and have a vocation or have a job. A prison, though, is different. In the state of Massachusetts, it's run by our state government. And there we typically see inmates who have committed more serious crimes and have a prison sentence of, more than 2.5 years. And this information, by the way, is taken from there. Now, getting back to crimes, we have two ways that crime can be classified. First, mala in se, and second, mala prohibita. I want you to think if you know, for example, if you have taken Spanish or French, right? Mala in se. We know that the term, like I can speak Spanish, so I can tell you this. Mal means bad, right? And if you say, that comes from the verb to know. So that means that these are things that are bad because we know that they're bad. For example, everybody knows that murdering someone is bad, right? That is just sort of inherently criminal in nature. Mala prohibita is different. So it's bad because it's prohibited, meaning that these acts are not necessarily considered criminal, but they are because legislatures have made them so. So, for example, drugs. We perhaps have grown up knowing that drugs are bad. So, what you would say, well, aren't they mala and say? But theoretically, drugs are just bad because legislatures have said that they are against the law. Okay, so important connotation, important thing to know. All right. Moving on. And I gotta erase that stuff. Okay. Last thing in this here, this presentation is about statute of limitations. The statute of limitations is a period of time where the state has to begin a case for someone that has committed a crime. So the more violent a crime, the longer the statute of limitations. And there are a few exceptions. But it's almost like there's a timer, right? And you think of those little sand timers that you might get in a board game. When the state thinks that you've or a crime has been committed, they have a certain amount of time. It's like that timer flips over, and before time runs out, they have to prosecute for that crime. So let me give an example. According to Massachusetts general law, which we call MGL, which we'll talk about more, there is no statute of limitations, meaning if you were 20 years old and committed these crimes, you, let's say, weren't found, evidence didn't come about until like you were 90 years old, you could technically still be prosecuted for these crimes. So murder has no statute of limitations. Indecent assault and battery on children under the age of 14 or a person with intellectual disability. Reckless behavior with risk of harm or sexual abuse to a child. Rape of a child. Rape and abuse of a child, and assault of a child with intent to commit rape. And so one example that's been in the news in the last decade or so is that there have been some cases of people who are members of clergy in various churches, and particularly the Catholic Church. And some of these men who were priests had committed crimes against children maybe when they were 20 or 30. And some of them are now in their 70s or 80s and are still getting prosecuted for these crimes because there is no statute of limitations on these crimes. Now, there are statute of limitations, though, for other crimes. So if someone is raped or assaulted with intent to commit rape, that evidence is collected, and the police have basically 15 years to find out who did it, right? And to try to prosecute that person for the crime. Now, if it's year 17 and new DNA evidence has come to light that they found the person, they might not be able to actually prosecute that person because the statute of limitations has run out. Within 10 years of offense, we have armed robbery, assault on people over the age of 60, and incest. And then typically every other crime is 6 years. Within 6 years of the offense is the statute of limitations. So that concludes my presentation on where law comes from and the classifications of law in general. So if you have any questions, please make sure to ask me during class. Thanks.